unmuted.
Well, good afternoon, everyone. This is Tony Trahan with the Office of Mental Health. I want to thank everyone for attending this webinar on the ADA. For people who are just joining us for the first time or who are not familiar with webinars, let me just introduce you to a couple of concepts. Due to the number of people that we have, we do have to keep the lines muted. Please feel free to ask questions via the chat function on the webinar control panel. And you can see the slide up here right now and you can ignore this audio number down here. That's not active. As you can see on the control panel, where the arrows are pointing, enter your question for staff there. And then if you want to close the control panel, if you go to the next slide, you just press the arrow there, and that will minimize the control panel for you. So you'll be able to see all of the slides in their entirety. During the webinar, you may experience some momentary lapses in the audio. This is normal and should not interfere with the overall content of the presentation. If there is an extended period of lapse in the audio, we will be working to fix it expeditiously, and that did happen to us a little earlier today, but we were able to rectify it within a couple of minutes. The webinar is being recorded and it will be archived, and you will receive the link to the archived version in a follow-up email. Please feel free to share this link with other people in your agency or with anyone else that you feel is appropriate. We currently have 55 people on the webinar right now. We'll probably get a few more as we go along. And when the webinar ends, you will receive a short survey. If you could please take the time to fill this out. Everyone attending will get a certificate in the email. If people are sharing a computer to view the webinar, if you could please just list all the people who are requesting a certificate, and they will all be sent as attachments to you in one email. So today's presenter is John Allen, and he was also our presenter last month. Mr. Allen is a noted speaker and author on disability rights issues, entitlements, homelessness, disability employment, and recovery. He is committed to assuring that recovery from mental illness is possible for everyone. In 2002, Mr. Allen came to New York State, where he served as the coordinator of outreach for the New York State Project Liberty. His role was to ensure easy access for special populations to the education and counseling programs provided by FEMA after the 9/11 disaster. Currently, Mr. Allen serves on the executive staff of the New York State Office of Mental Health, where he is a special assistant to the commissioner and the director of the Office of Consumer Affairs. Also, his federal training credentials include recognition by the Department of Justice as an expert on ADA issues. And on a personal note, I just want to mention that John is one of the hardest working and passionate advocates I've ever met. He is someone who is a visionary and who has advanced the integration of people with disabilities for decades to come. It's my pleasure to welcome him today.
Great. Thank you, Tony. And I'm delighted to actually talk about the Americans with Disabilities Act, in part because a lot of people talk about it, but yet, in spite of talking about it, a lot of people really don't know what the ADA says or is. Today's webinar is going to focus on the Americans with Disabilities Act. In some future webinars, we'll talk about the Fair Housing Act and some other pivotal statutes which provide rights for people with disabilities. And so let's begin with the ADA itself. And what is the definition of disability? Now, throughout this webinar, I'm going to use the words that are embedded either in the Americans with Disabilities Act or the associate accompanying documents which make up the various technical assistance guidelines for the Act. And so the definition of disability under the Americans with Disabilities Act is actually a three-pronged definition. By three-prong, I mean that there are three different parts to the definition, and you can be perceived as being disabled and eligible for protection under the Americans with Disabilities Act, depending on what part of the definition affects you as a person. So the first prong of the definition is that you are a person with a disability, meaning that you have a physical or mental impairment that substantially limits one or more major life activities. Now, Major life activities are defined as caring for oneself, walking, hearing, breathing, working, performing manual tasks, seeing, speaking, and learning. We have to really focus on this because other things that we may call disabilities may or may not fit this part of the definition under the ADA. The second prong of the definition is a person with a record of a disability. And so what does that mean? It means that a person has a record either in a medical record or a record of SSDI or other institution where at some point in their life they were a person who met the first prong of the definition, i.e. they had a disability that affected one or more major life activities. So if I've ever had one of those, I could be regarded as having a disability by virtue of the fact that there's a record that I've had a disability. Now, the third prong of the definition is someone who is regarded as having a disability, and this is someone who may or may not have an impairment which substantially limits life activities, but they're treated as if they do, or that they have an impairment that substantially limits one or more of life activities only as a result of that diagnosis based on people's attitudes. Or that they don't have any impairment at all, but they're treated as if they have an impairment. And so an individual may be regarded as having a disability if people around them generally believe that they have a disability, whether or not they actually do. And so under certain circumstances, I cannot, under the law, be discriminated against simply because I'm regarded as having a disability. So let's look at what the ADA says and how does it work. Well, one of the fundamental provisions of the Americans with Disabilities Act that goes to the enactment of the Act is that individuals who illegally use drugs are not covered under the ADA. Now, if I've used drugs in the past, but I'm not currently using drugs, having an addiction is a disability under the Americans with Disabilities Act. But the ADA, and Congress was very explicit in this regard, does not allow you to use the Americans with Disabilities Act to cover current illegal drug use. And so historical drug use and problems, I need treatment, I need rehab, I need to be employed, those are in fact covered under the ADA. But if I'm currently using illegal drugs, that I'm no longer covered under the Americans with Disabilities Act for protection against discrimination. And in fact, employers, agencies, and others can in fact use illegal drug activity to screen me out. So when we talk about substantially limits major life activity, what do we mean? Well, we mean that the disability significantly restricts the ability to perform either a class of jobs or a broad range of jobs in certain classes, or it changes my ability to perform as compared to an average person who doesn't have disabilities. And so if I have the same skills and training that someone else has, but because of my disability, my performance is impaired, then this is something that would substantially limit a major life activity. Now, I want to talk a little bit about the context of the Americans with Disabilities Act, because it's important to note that the Americans with Disabilities Act only covers a variety of public entities and does not cover the federal government. And there's a reason why that's very explicit to the history of the ADA. I'll explain that in just a minute. So in the United States, we have a history of dealing with disability in a variety of ways. So if I go back in history, disability was originally dealt with in terms of what people call the rehabilitation or charity model, that the burden of dealing with the disability on an individual was really on the individual, and society as a whole had no responsibility for helping people with their disability except to be charitable and occasionally offer donations or the like to help a single person. Then came the Civil Rights Act of 1964. And the Civil Rights Act of 1964 prohibited discrimination in terms of employment, accommodation, and receiving federal funds. It did not include disability, but it included age, race, ethnicity, and language as prohibitions in employment, in public accommodations, and in receiving federal funds. This was the beginning of the public thinking about rights in general, and so many of the things that refer back will often refer back to the Civil Rights Act as the basis for which Congress was empowered to act, and in fact, the Supreme Court upheld a variety of these means and mechanisms as a result of the Civil Rights Act of 1964. There also was an important act that many people are unfamiliar with, which was called the Architectural Barriers Act of 1968, which provided that certain public buildings or buildings funded with public dollars began to address architectural barriers that limited people with disabilities' ability to use those programs. This was the beginning of the installation of ramps and elevators to make buildings accessible for people with disabilities. That goes far beyond the use of ramps. Actually, a certain distance between barriers, as a simple thing like bathroom stalls, is important for someone in a wheelchair, because in order to be able to access a building, the wheelchair and anything that sits on either side of it needs to be able to fit through doorways and entryways. So standard doors are 30 inches. Oftentimes we need to be greater than 30 inches to comply with architectural barrier removal in a variety of ways. And this act actually specifies what are the standards for many of those things. Here is the core of the fundamental foundation of the Americans with Disabilities Act. Section 504 of the Rehab Act of 1973, for the first time, provided a federal law with a protection for people with disabilities from discrimination in federal government programs and those programs receiving federal funding. The Americans with Disabilities Act itself is primarily based on the language of the Federal Rehab Act, and Section 504 is often called the Federal Rehab Act. The concepts of reasonable accommodation, of disability, are actually built upon this particular statute and actually extend the Rehab Act beyond the federal government. Now, I said the ADA does not apply to the federal government directly. It's because Section 504 of the Rehab Act actually provides the mechanism for compliance with federal government and federally funded programs. The ADA applies to the rest of the world, and we'll talk about how that provisions play out. Now, Section 504 did a couple of very specific things. It recognized that all people with disabilities belong to a class, and that class is important in federal language, because if I belong to a class and it is a protected class, then I'm entitled to certain rights. And that in order to be a protected class, the class of people have to have a common experience of discrimination. And so Section 504 for the first time recognized that people with disabilities, in fact, were a class of people who were commonly discriminated against in the use of federal programs and federally funded programs. In 1975, we had what has later become the Individuals with Disabilities Education Act. In 1975, it was called the Education for All Handicapped Children Act, Public Law 94-142 of 1975. It's been renamed IDEA, and the concept of this act was to ensure that individuals with disabilities got fair and adequate education services. IDEA mandates a free, appropriate public education for every child with a disability in the least restrictive environment appropriate for that child. Now, least restrictive is an important term because that's the basis of many of our historical laws about disability and many of the court decisions, which contemplated that individuals should be served in the least restrictive environment. And so since 1975, up till the passage of the ADA, the concept of being served in the least restrictive environment was in fact the law of the land, as articulated by a number of courts and court decisions. In 1986, there became a statute for airlines called the Air Carrier Access Act, which protected people with disabilities from discrimination in air travel by private airlines. Curiously enough, this act did not mandate that airlines provide supports and the ability for people to use them. And so one of the fundamental architects of the Americans with Disabilities Act, Justin Dart, who was at one time the Secretary for the President of the United States around a number of issues, and who regularly tried to fly to appointments and meetings, had to literally get out of his wheelchair and crawl up the stairs to get on a Pan American airline. Pan Am was the airline at the time, and literally drag himself down the aisle on his hands and crawl up into a seat with no help or assistance from any of the staff of the airline. That was a fundamental principle that got Justin thinking about the fundamental rights of people with disabilities. And although we had the Air Carrier Access Act of 1986, there was no affirmative requirement for airlines to assist individuals with disabilities in being able to use that service. They were simply prohibited from discriminating against, which meant simply, I don't have to give you anything special. If you can crawl down the aisle, I have to serve you. And Justin used that to make a point that airlines needed to come up with a different way. The carrier carts, little wheelchairs that are used on airlines today, are a direct result of Justin Dart's public civil disobedience of telling the airline that it was required, in fact, to fly him and couldn't discriminate against him. But in fact, the airline made the point that they didn't have to provide him any assistance to get on the plane. Then came the Civil Rights Restoration Act of 1988. And at this point, disability became accepted by the broader civil rights community to begin being incorporated into the civil rights and laws protecting generic civil rights across the lay of the land. The Fair Housing Act amendments of 1988 did a number of things related to, again, disability, but broader civil rights as well, prohibited discrimination in the selling and renting of housing. So many people aren't aware that the ADA doesn't directly apply to housing except in certain circumstances, but the Fair Housing Act and the amendments of 1988 do. And so provisions like reasonable accommodation, which we'll talk about more, are actually part of the Fair Housing Act and based upon that. The Fair Housing Act amendments provided that landlords must allow tenants to make access improvements at their own expense, meaning that if I needed a ramp or I needed counters raised or lowered as a result of my disability, that landlords had to provide that. And they went further to say that new multifamily housing must include basic features of accessible design, meaning that if I'm a person with limited mobility, the multifamily housing must include the ability for me as a person who uses a wheelchair to be able to access that housing and visit friends, family, relatives, or neighbors. That's particularly important. The last piece is it prohibited discriminatory zoning practices. So when we look at zoning practices around housing, it's not the ADA, it's the Fair Housing Act, because the Fair Housing Act says that you cannot discriminate on the basis of race, color, creed, religion, sex, national origin, and disability in terms of zoning practices. So then came the American with Disabilities Act, and the American with Disabilities Act has 5 primary parts, and each part addresses certain components of the Act. Title I of the ADA is around employment, and it's public sector employment, not government employment. Title II affects public accommodations. Title III affects activities of state and local government. Title IV affects transportation, and Title V affects telecommunications. So let's go through each of the titles of the Americans with Disabilities Act one at a time and look at what the Act both says and what it covers. So, again, each of the parts of the ADA are considered titles. There are a couple of subparts under public entities. There's a general and a transportation section under Title II. And under Title III, there's also another transportation section. So let's look at Title I. Title I of the Americans with Disabilities Act affects employers with 25 more employees as of July 26, 1992, and 15 or more employees after that point in time. Only employers which have more than 15 employees are actually covered by the ADA. Those businesses with less than 15 employees are not covered as an employment entity under the Americans with Disabilities Act. The ADA does not apply to private membership clubs, and this includes country clubs and other private organizations. And the criteria for identifying if a membership club is exempt, there has to be a substantial fee. They have to have a limit on how many people can join. The membership control is controlled by a selection process. There has to be criteria for admission, and there has to be a formal admissions process. So in order to be exempt from the ADA as a private membership club, you have to meet all of this criteria. So one of the things that many people heard about recently was that some private golf courses actually are private membership clubs. Curiously enough, Tiger Woods played at one of the golf courses that is a private membership club down in the southern part of the United States. That club still prohibits women from joining. Although the Civil Rights Act says you can't discriminate on the basis of sex, they're able to because they're not covered under the statute since they are a bona fide private membership club. And so it's important to note that private membership clubs are not covered under certain parts of the statutes. So under Title I, a qualified individual with a disability, and this is important because only a qualified individual with a disability is protected from employment discrimination, meaning that if I'm not qualified to do the job anyway, I'm not protected by the Americans with Disabilities Act. And so the easiest example that I can give is a brain surgeon, someone who has never been to medical school and has no license to practice brain surgery cannot say that they're being discriminated against because they're prohibited from becoming a brain surgeon, because they're not a qualified individual with a disability. And so the beginning part of this definition is I have to have the qualifications to be able to do the job. So I've got to be able to satisfy the requirements of the job. Now, a fundamental principle of that is with or without accommodation, I have to be able to perform the job. So one of the things that I can ask for in terms of employment is accommodations that would help me to be able to do the job. And a good example is a research person who is blind, who needs a reader in order to be able to read non-braille documents to be able to do their research. That would be an accommodation. Can they do research even though they're blind and look at printed material? The answer is with appropriate accommodations, absolutely yes. An example of someone who would not be a qualified person with a disability, at least today, under the current technology that we have available, is someone who's blind who wants to be a commercial airline pilot. And the reason is I need the visual acuity under our current technology to be able to fly the plane. Now that said, at some point in the future, we may have technological advances which could provide the reasonable accommodation to be a truck driver, a bus driver, or an airplane pilot with blindness as one of the factors. But those technologies do not exist today, and therefore I would not be considered a qualified with an individual, as a qualified individual with a disability as a part of that. The last part of the qualified individual with a disability is I have to be able to do the essential functions of the job. And essential functions are those job tasks that are fundamental to the job and not marginal. So a good example of that would be to be a proofreader. And so could someone who is blind and visually impaired be a proofreader of a printed text document? Well, the essential function of the job is being able to not just hear the words and look for typos and misspelling, but also to check punctuation in the documents. And if I don't have the visual acuity to be able to see that, and our current technology on readers does not provide that opportunity, then I would not be able to perform the essential functions of the job. If I was to have a staff person assist me, then that staff person would be doing the essential functions and I would not. And so a qualified individual with a disability has to be able to perform the essential functions of the job. So what makes a job task essential? Well, if the position exists to perform that function. So a perfect example would be a mover and an individual with a disability who cannot lift more than 10 pounds but wants to go to work for a piano moving company says, but I'm a qualified person for this job, but they can't lift more than 10 pounds. So do they meet the qualifications? Well, it depends, as it does in many of these things, because there are technologies available to assist a person who has limited ability to lift weight to actually use technology to assist them. There are hydraulically driven exoskeletons that can lift many thousands of pounds in spite of what an individual might be able to lift. So in this case, with the appropriate accommodation, I might be a qualified individual, but without it, I would not. The second thing that makes a job task essential is the number of employees from whom a task can be distributed. If I only have one person who is the receptionist, who has to answer the telephone, and because of their disability, they are mute, they do not have the ability to speak, and they don't have the ability to use a TTY or teletype, in part because of either mobility or physical impairments. And we only have one receptionist. They would not be a qualified individual, in part because I couldn't ask another staff person to perform that essential function. And the last is, if a task is highly specialized, and again, I'd use the brain surgery as the technique. Well, if I'm not have the skills and the license to be a brain surgeon, and I don't have the ability or the dexterity to perform that skill, then I may or may not be essential there. So evidence of whether a function is essential, this is important in looking at whether I can follow a discrimination case or not. An employer is going to be asked to provide these kinds of experiences, and the Equal Employment Opportunity Commission is going to evaluate these types of parameters to determine if a function of a job is essential. Now, employers have to make, under the statute, reasonable accommodations. And a reasonable accommodation is defined as a modification of policy, practice, or procedure. There is one exception to the reasonable accommodation rule, and that is if it would create an undue hardship or burden. So employers have to make accommodations both in the hiring process and the ongoing employment process unless there's an undue hardship or burden. So what is an undue hardship or burden, and what is a reasonable accommodation? Well, let's start with the accommodation piece first. A reasonable accommodation could mean a modification to the application process. It could mean a change in the work environment or a manner in which the job is performed. It could mean providing equal benefits and privileges to individuals. Some examples of reasonable accommodation might include job restructuring, modifying a work schedule, making a building accessible, acquiring or modifying equipment or devices, providing a braille reader or interpreter. It may include providing an assistant, a reader, an interpreter, or someone to help an individual. Or it may mean an employee who's acquired a disability gets reassigned to a vacant position to accommodate someone with the individual. Preference for applicant for particular accommodation gets primary consideration, meaning that if I ask for an accommodation as an employer, you are obligated to give me the type of accommodation that I ask for, unless another accommodation would provide meaningful equal employment opportunity, or the one that I prefer creates an undue hardship or burden. So I need to note here that many individuals with disabilities don't require any accommodations at all. Because it's important to note that although businesses often say people with disabilities are more costly to get employed, the actual answer, according to a number of federal studies, is that people with disabilities cost an average of less than $7 to provide all accommodations that they need to be employed. Pretty insignificant in the scheme of things. Now, an undue hardship or burden around accommodation, and it's the only exemption that employers have for not providing an accommodation, means that what you're asking for requires significant difficulty or expense, or it's just so costly, extensive, substantial, or disruptive, or it fundamentally altered the nature of employment. And so an example of an accommodation that might fit an undue hardship or burden would be where the building is in historical restoration. That is the job. So we're doing restoration of historical buildings. Historical buildings are not generally handicapped accessible. And yet, as a person in a wheelchair, I need to be accommodated to be able to go in to do the restoration of that historical building. But making the building accessible would destroy the historical integrity of the building. That would be an undue hardship or burden, because as an employer, I can't do both things, maintain the historical integrity of a place and make it handicapped accessible, particularly if there's artwork or other things that make widening some of the entrances or corridors or passages prohibited. So factors to consider in undue hardship or burden is the nature or cost of an accommodation. And that is in addition to any tax credits or deductions or outside funding that we can bring in. So if something were to cost millions of dollars to accommodate, it may or may not be an undue hardship or burden depending on how big the organization is. So a large multinational corporation has less defense around undue hardship or burden than does a small private employer, because arguably, as the courts and Congress decided, a large employer has more resources to accommodate more types of things. The financial resources of the facility and number of employees are important to consider. The resources of the employer, the type of operations, and the impact of the accommodation on operations of the facility. So, the qualification standards. If someone's applying for a job, does an employer have a right to set standards by which they have to meet? Well, yes, and an individual with a disability has to meet those job standards. Qualification standards have to be job-related and consistent with business necessity. So, for example, if I was looking for someone to be a window cleaner, being not afraid of height and able to work on the scaffolding that rides up and down a tall building might be a reasonable accommodation. But being able to take care of bees probably is not a legitimate requirement unless I was a beekeeper. And so making sure that the job standard and qualification is consistent with the needs of the business. There also is, in the accommodation process, that an individual who creates a significant risk of substantial harm to others, either of themselves or to others, is not eligible for a reasonable accommodation. And the easiest example that I can give here is a tall building window washer. Oftentimes these individuals ride what literally is a scaffold that is only a small place wide up and down a narrow cable up and down the building. If I have limited mobility, the ability to keep both of us on that scaffolding safe is not able to be mitigated by any technological advance that we currently have today. So if one of those cables snaps and fails, both of us need to be able to maintain ourselves and be able to identify and get to the safety appliances to help us be able to literally live and survive. And so in that regard, I may not be able to eliminate the direct threat, but the threat has to be real, not imagined. And so just because I believe someone might be at risk of harm doesn't mean that I can use direct threat to say that the ADA does not apply to them. There actually has to be real risk of harm. Another example would be that I can think of that might help make this clear is a salvage diver who dives deep sea diving to salvage certain devices. If a person had a substantial breathing impairment, the ability to dive and be safe using mixed gas structures could be very limited. And so would it pose a direct threat to the individual and the individuals that they're working with if they could not maintain their safety underwater using compressed gases? And the answer is yes. And so in that regard, unless there's a way that we could mitigate it with technology, we would not be obligated to provide the accommodation for that person. So direct threat factors, duration of the list, risk, nature and severity of it, the likelihood of harm, and the imminence of harm. Remember that illegal use of drugs and alcohol can absolutely be prohibited in the workplace, that the influence of it can be prohibited, that employers are still required to comply with the Drug-Free Workplace Act, and that employers may hold a drug user or person with alcoholism to the same standards, and that drug testing is permitted. Remember, what is protected under the ADA is the history of drug use and drug treatment for addiction, not the current use. If I am currently using drugs and actively on an illegal substance, I am not protected by the ADA around employment. Now, in employment, medical exams are permitted, and they're permitted at various points in time. So, during a qualification exam, during the application process, I can require a medical exam that are you able to perform the essential functions of the job with or without accommodation. What I cannot inquire about is do you have a disability? And so questions on applications that say do you have a disability generally are deemed to be illegal questions. If there's a test required, it has to be administered in a format that does not impact a person with a disabilities impairment, and that in interviews I can never ask about a disability, nor in background or reference checks can I ask about disability, and medical exams can only be conducted after a job offer is tendered. Now, in employment, there's another provision of the ADA which says that an employer cannot discriminate against an individual on their basis of association with an individual who is disabled. And here the most common example that I can give is I happen to be friends with a person who has HIV, and my employer does not provide me advancement or other opportunities because they're afraid that I might develop HIV because I'm friends with someone that does. That's discrimination on the basis of association, and that's prohibited under the ADA. So the ADA has some general relation to other laws, and so the general provision is that if the other law provides greater protection, then the other law takes precedence. If the other law provides less protection for the individual, then the ADA takes precedence. Now there's one exception. Remember that the ADA does not apply to the federal government, nor does it apply to federal laws. So the exception is federal laws, which have greater or lesser protections than the ADA, the other statutes stay intact. Now, in employment, insurance and health insurance in particular is often a part of one of the provisions of benefits of employment. That under the ADA, I can't be denied insurance based on my disability, they cannot give me an increased cost as a result of discrimination, that any decisions that we have to be based on what are called actuarial tables and data, and that under previous law, and this is about to change, pre-existing conditions and the ability to discriminate against them are legal. Now, under the Affordable Care Act, as it's being implemented, pre-existing conditions will no longer be applicable come 2014. And limits to coverage are also permissible under the ADA, but that will too change under the Affordable Care Act. So if I was to look at applying for protection under the ADA, this is where I would go. I'd look at the Federal Equal Employment Opportunity, the EEOC laws. And there are a number of places that I can use to file for discriminatory practices. Title VII of the Civil Rights Act prohibits the discrimination on race, colors, religion, sex, national origin. The Equal Pay Act of 1963 protects men and women. Age discrimination in the Employment Act of 1967 affects older workers and protects them. And Title I and Title V of the Americans with Disabilities Act affect employers against discrimination of individuals with disabilities. And so the EEOC, the Equal Employment Opportunity Commission, is the place that I would go to enforce the beginning provisions of violations of my civil rights as a person with disability. Remember that Section 501 and 503 of the Rehab Act prohibit discrimination against people with disabilities in the federal government. And the Civil Rights Act of 1991 prohibits discrimination and provides monetary damages in the case of intentional employment discrimination. And that's one of the things that have radically changed how we look at discriminatory practices today, when an employer can be held to monetary damages as a result of that. So enforcement for Title I, discrimination under the ADA, are filed with the Equal Employment Opportunity Commission. Here's their contact information. Generally speaking, cases must be filed within 180 days, and the EEOC can issue a right to sue letter at any point in time if you wish to take your lawsuit to circuit court. That's the primary provision of the Americans with Disabilities Act related to employment. I'd like to focus just briefly and give you a teaser for the Title II, Title III, Title IV, and Title V sections of the ADA, which I'd like to do in subsequent trainings that we might do. Title II of the ADA provides accommodations around what are called public accommodations. Public accommodations are those places and opportunities, excuse me, those places and opportunities for individuals to congregate. They include business settings, healthcare providers, and other settings. So I can't be discriminated against in terms of access to places to shop and other provisions. We'd like to do a subsequent webinar on Title II and Title III. Title III affects state and local governments. State and local governments are also prohibited from discriminating against people with disabilities in both employment and in services. And so at a local level, every local municipality, every county, every city, every local government is governed by the ADA under Title III of the Americans with Disabilities Act. Title IV and V are related to transportation and telecommunications. And these are significant because prior to the telecommunications section, individuals who were deaf did not have the ability to communicate with non-deaf individuals, except in some local areas which had what were called private relay networks. Under the ADA, the ability for meaningful communication is one of the primary principles that exists today. And so individuals are both protected and afforded an opportunity to be able to participate in programs generically as how this would play out. So as we look at Title I of the Americans with Disabilities Act, a couple of key components to recap are that I'm entitled to reasonable accommodation during the application process. I'm entitled to reasonable accommodation after I get employed. To be eligible for reasonable accommodation, I have to disclose that I'm a person with a disability, because otherwise I'm not entitled to the accommodation. And I may or may not have to provide documentation that I have the disability in order to receive the type of accommodation that I request. Remember, too, that employers have the right to assert an undue hardship or burden if I request an accommodation which fundamentally alters the nature of the work or creates a cost prohibition on being able to access certain things. The other provisions of the ADA answer some of the questions that we saw on the preliminary signing up list of questions people had. But quite frankly, as we knew would be the case, many of the things that people believe the ADA provides protection around, it actually does not. The ADA is very specific around employment, public accommodation, state and local programs, transportation, and telecommunications. That's the areas. So when you ask about banking rules, well, the ADA may affect certain provisions in banking if a bank discriminates against me on the basis of disability, but it does not apply the ability for me to look at savings to start up a business. There are other things related to that. It also, likewise, doesn't help me pay for a degree if I want to go back to college. That's not what the Americans with Disabilities Act was for. It was designed to provide an equal playing field for people with disabilities who had skills to be able to use those skills in a setting. So why don't we go to some questions, and I know we've got some queued up, and I'll try and go through some of those and answer those related to Title I or either of the other sections of the ADA if questions arise on it. And we'll plan on doing at least one or two more webinars on the ADA to cover Title II, Title III, and then the telecommunications and transportation sections as well.
So yes, when we initially announced this, we did bill it as one of three on disabilities rights. So we also noted the Federal Rehab Act and the Fair Housing Act. But if we want to expand that, we always can. I don't have dates for those just yet, but we will do one in January and we'll do one in February, and we'll send those out and post them. We have a very short list of questions, and since we do have plenty of time, what I wanted to do was sort of bring up a couple of things that I just want to highlight a couple of things and ask you a couple of questions about people with disabilities who are working.
All right. So actually, Tony, before you do that, why don't I go through some of the questions that are appropriate to Title I in the questions that were submitted prior to this. And so let me go through those, and then you and I can talk a little bit, and then we'll answer the questions here.
People, feel free to keep sending in your questions.
So one of the first questions that was asked that's relative to this is, how can the Americans with Disabilities Act conquer stigma and community discrimination specifically? Well, under Title II of the ADA, the Public Accommodations section, public accommodations, and there are 7 things that are considered public accommodations, are prohibited from discriminating on the basis of disability. Now that said, there are only 7 things covered that are prohibited from discriminating on the basis of disability. So how can the ADA help? Well, one of the ways that it can help is that we can use the ADA and the Federal Rehab Act to help educate people in a variety of ways to be able to integrate into their communities. And one of the fundamental nature of the Americans with Disabilities Act, which is a change in the way the statute was created and in the history of this, is in the previous stages, the legal requirement was the least restrictive setting possible. Under the ADA requires the most integrated setting possible. Now, that's a fundamental shift. And so the most integrated setting says that, as the Supreme Court has held, that we need to be integrated into the fabric of our community, which is a fundamental cornerstone of the breakdown of stigma and discrimination. Based on the civil rights struggles, we know that it is easy to discriminate against people who I don't know, who I never come in contact with. Stigma and stereotypes become much harder to perpetuate when I know individuals that are part of a protected class and I meet them and meet more of them. So community integration is a standard both in law and in the ADA that affords us an opportunity to begin to break down some of those discriminatory acts. The next question was, how does mental health disabilities fit into the Act? And this is actually interesting. During the passage of the Act, there was one individual and one alone who was fundamental that mental health be included in the Americans with Disabilities Act, and that was Justin Dart. Having had an opportunity to meet with he and his wife a number of times at their home during the advocacy around passage for the ADA, many of the disability groups did not want psychiatric disabilities to be included in the Americans with Disabilities Act simply because they were concerned that everyone would get identified with the stigma and discrimination of psychiatric disabilities. Thanks to the heroic advocacy of Justin Dart, Justin made it very clear that he would not, as sort of the leader of the consortium that was pushing for the ADA, he would not move for passage of the Americans with Disabilities Act unless it did include people with psychiatric disabilities. So psychiatric disabilities are absolutely part of the Americans with Disabilities Act. The one area where disabilities are in the Act but also excluded certain acts is around addiction services, and I identified that in terms of employment. The same restrictions apply to the other provisions of the ADA. A historical addiction problem, current addiction treatment are prohibited from discrimination, but current substance use is still an illegal activity, and the ADA does not protect against that. How do individuals with bipolar and ADD look for accommodations? Well, one of the great resources around accommodations is something called the Job Accommodation Network. And the Job Accommodation Network is operated out of the University of Wheeling, West Virginia. JAN, as it's commonly referred to, is available online and provides a number of technical assistance places. Tony is now going to actually bring up the JAN website so you can take a look at it, I believe. And it is a wonderful resource that if you don't know how to accommodate a particular kind of disability, they can actually help you with that and look at ways that you might be able to be accommodated. Also, there are, on a regional basis around the country, programs called Disability Technical Assistance Centers, often abbreviated DEBTACs. Those DEBTACs exist to provide opportunity both for individuals with disabilities to look at and try a variety of technical accommodations that might help them be able to be accommodated in the workforce, and also provide opportunities for employers to try out a variety of different accommodations. DEBTACs are typically associated with independent living centers, and a number of our independent living centers here in New York State actually have a DEBTAC. The next question here is on an application asking if antidepressants are taken. Well, according to the ADA, asking about disability on an application is a prohibited act and considered discriminatory. And so unless there's something very unique about this employer that would require that as a bona fide occupational qualification, I would generally believe that that would be, in fact, a discriminatory practice subject to Equal Employment Opportunity Commission protection and enforcement activities. A couple people brought up the issue of termination of parental rights on the basis of psychiatric or developmental disabilities. This is an area that is unique in New York. New York is one of the few states that has a provision in Child Protective Service law, which allows for the termination of parental rights on the basis of mental deficiency, psychiatric disability, by diagnosis. Now, in practice, according to the Office of Children and Family Services, they don't just terminate parental rights on that basis. And there is a historical set of precedents in the courts that say that, and I'm going to use their words, not mine, but that you're afforded added protection if you have a psychiatric disability because you're given the potential to be evaluated by a psychiatrist to determine if, in fact, you would be a stable parent. I know from talking to many people with disabilities that say that that's not a protection at all and not a right that they would ever want to afford, particularly when it wasn't their psychiatrist who knew them intimately well. This is an area that's still unresolved, and many advocates believe that this is a violation of the ADA, and we'll have to wait to see how advocacy and advocates play it out with a sister state agency here. Public meeting requirements for notices and accommodation. This is actually under potentially several sections of the Americans with Disabilities Act. It could be under Title II for what are called public accommodations. There are 7. It could be under Title III of state and local government. So I'm assuming when we talk about public notices or public meeting notice requirements, we're probably talking about Title III of the ADA, which requires not so much that meeting notices be specific to people with disabilities, but that they be in accessible formats and posted in places where people with disabilities would have access to them, and that meetings are generically held in places that are available for people with disabilities to participate. Now, that being said, again, I have to use the example of if a meeting is in a historic building or in a private structure that cannot be accommodated, that may become an issue. The next person says issues that code officials grandfather in facilities and tell them they do not have to remodel for access. That is in fact true. A building which has existed for a long time that is not accessible does not have to make themselves accessible. However, if at any point in time they apply for a permit to modify, to add on, to change any part of that structure, then the area between the entryway and the part that they modify has to be brought up to accessibility standards to make that part of the building accessible for people with disabilities. But note that the law does not require that the entire building be brought up to that standard. Only the space between where they're remodeling and the front entrance needs to be modified. This was important because it allowed a number of older buildings to not have to spend literally millions of dollars modifying until they were ready to start making other modifications. And as they make other modifications to those buildings, then they need to comply with the current accessibility standards. The next one just says a wide range of reasonable accommodations have been provided to people with psychiatric disabilities. That's absolutely true. And the way that you can find out about a lot of them is the Job Accommodation Network. Actually, most people with psychiatric disabilities, according to the Federal Office of Contract Compliance study that was done, most people with psychiatric disabilities require no accommodations or a slight accommodation and modification of work schedules so that they can attend therapy sessions. And those are generally considered to have no cost associated with them at all. So the next question is, what are the similarities between New York State Building Code and ADA access requirements, and how can you involve code officials in ensuring accessibility? Well, accessibility is not mandated by the ADA with the exception of the 7 public accommodations. And so in our next section, we'll focus more on accessibility because public accommodations, the 7 types of entities, have to be accessible. All other buildings do not, by ADA, have to be accessible. What current legislation's on the books we've already talked about. The ADA Restoration Act took care of a couple provisions in the ADA. One was the courts held that Congress did not show a pattern and practice of discrimination broad enough for Congress to act upon the passage of the ADA, and that the ADA Restoration Act modified some of the language of the ADA to ensure that some of the provisions would in fact be protected as a result of congressional activity. What types of diagnoses qualify under the ADA? Well, diagnoses don't qualify under the ADA. Remember that the definition of a disability is something that impairs one or more of life's major activities. So that's the definition. It's not a diagnosis. When are waivers appropriate for integrated settings? Well, there isn't per se a waiver from the ADA. You must comply with it if you're a public accommodation or if you're a state or local government. The one exception is undue hardship or burden, which means that I don't have to apply certain types of accommodations if you request them, if it's an undue hardship or burden. And so that's the only nature of the waiver that exists. Will the ADA help a legally blind person who has received skills training get a real job? The answer is the ADA doesn't help you get a job or deter you from getting a job. Only you can really advocate for yourself to get a job. What the ADA does is it makes it illegal for employers to discriminate against you on the basis of your disability in the hiring, employment, promotion, and benefit phase of actually having and obtaining a job. And so it's not an affirmative hiring requirement. Certain federal contractors do have affirmative hiring requirements, but that's not a specific one that is specific to the ADA. So Tony, why don't we go to some of the dialogue that you were getting ready to start, and then some of the questions that we had.
So without a specific question, someone did ask if we could talk more a little bit about mental health and how that applies to substantial risk. But what I was thinking was, so if I'm a mental health client at a program and I want to apply for it, they have a job there that's available and I'm qualified to work there based on their job description. Can they say that they couldn't hire me because I'm using the program? I mean, is that protected under the ADA? Or?
Well, this is something that frequently comes up. And what I would say under the rules of the ADA, and again, you'd have to look at the specific nature of the specific criteria, but generically speaking, if I was a qualified individual, I met all the other skills, and they said that I simply can't work here because I get services here or I got services here or those types of things, on the basis of disability, that would generally be deemed an illegal activity. And so can I discriminate simply because you get services at a place? Well, no, that would be generally an illegal activity.
Okay. Thank you. And another common thing, because a lot of people with mental health problems also have co-occurring substance use. If someone is currently using, aren't they still eligible to receive health care even if they're currently using? Or am I confusing this with another?
Well, it really depends. So if I'm talking about health care as an employee, does the employer have the right to terminate my employment because I'm a current user of substances? And the answer is very clear. The ADA provides no protection at all for someone who is currently using an illegal substance. Now, that being said, there is another section of law called COBRA, which as an employee, if I'm terminated, I have the right to maintain my health insurance coverage by paying the cost of it for a period of time. If I choose to elect COBRA and I pay for the cost of the coverage, then I'm able to maintain my coverage, but the employer has no obligation to continue health care after employment. And in fact, the employer has every right to fire me if I'm currently using an illegal substance, whether it's on the job or not.
So more specifically, what I was thinking was if I'm an active user and I'm part of a clinic going and receiving services from a clinic, could they, or even a physical health, could they deny me services because on the basis that I'm currently using?
Well, that gets a little more complicated, and there's two parts to the question as you kind of look at it and analyze the Americans with Disabilities Act response to it. The first would be, can a clinic deny me services because I'm currently using a substance? Well, on the basis of public accommodation, I have the right to access health care. And so health care is one of the 7 public accommodations that the ADA covers. And so in that regard, am I being discriminated against on the basis of a disability? One could argue the answer is yes. Now, does the health care provider have the expertise to provide a service related to my addiction issue? That's where it gets complicated, because typically what a healthcare provider will say, well, I don't have the expertise to deal with this issue, and therefore it is disruptive to our process and creates an undue hardship or burden. And so it's much more difficult to say that that clearly fits an ADA type of issue, because there are 2 sides to the coin, and when you get in a setting that they would begin evaluating it, on the initial basis, you might say, well, this is discriminatory. On the flip side, the provider is going to counter, I may not have the expertise to serve this particular issue, and allowing the individual with this issue to come into my facility is disruptive and creates an undue hardship or burden on other patients, making it problematic. Now, this kind of goes, though, to the question that you started to say, and that people brought up about what's the specific nature of risk, that harm that's possible because of a psychiatric diagnosis. Well, Congress was very clear, and the Department of Justice has been very clear in the interpretation of this section of standards. If it is simply the perception that because I have a mental health diagnosis, I'm going to be therefore be dangerous, that's clearly discriminatory. If, on the other hand, I'm actively suicidal, and you're asking me to be a bridge painter and to go up several hundred feet in the air on a bridge to paint it, that may constitute substantial risk, because if I'm currently suicidal, being 200 feet in the air and having the opportunity to jump off, not only might risk me, but other people around me in ways that an employer could say, no, that constitutes specific, actionable, substantial risk. But an employer generically cannot use a stereotype about a class of people to say that there's substantial risk involved. They actually have to look at the specific nature of the specific individual, what are their specific circumstances, what's the specific nature of the job, to determine is there substantial risk or not.
Now, how does the ADA apply to volunteer work?
Well, volunteer employment, the ADA may or may not apply depending on the nature of the volunteer work. So employment is generally seen as for monetary payment, although most programs that are volunteer agencies are generally not-for-profits. And not-for-profits generally receive public assistance in a variety of ways, which may or may not be state or federal funding, include state or federal funding. As such, they may be subject to various components of the ADA. And remember that the ADA only applies to employers that have 15 or more employees. And so we always have to look at how many employees does an employer have before we can say that they're absolutely covered by the ADA. Because if I only have 2 other employees, I'm not covered under the ADA by any means. Now, if I'm a covered entity and I have volunteers, then the same provisions related to the service of volunteering, so that becomes a service in a way, one could argue would be covered by the Americans with Disabilities Act in a variety of ways. And so volunteers arguably should be covered under the ADA, in terms of volunteerism, but it may not be under the employment prong. It may be under Title II or Title III of the ADA, depending on the unique circumstances in the environment in which they're working.
Okay, and our last question that we have up here is, what about non-citizens? So you haven't used the word citizen in defining who is covered by the ADA.
Well, curiously enough, Congress did not say that this only applied to U.S. citizens. Now, there are a couple of exceptions. So when we talk about employment, I must have the legal status to be able to work, meaning if I'm not a citizen, I have to have a green card or work visa or work permit to be able to legally work in the United States. If in fact that I do, then I'm covered by the ADA, Title VII, and all of the other standards that provide civil rights protection against discriminatory behavior. If I don't have the ability to legally work, then the ADA doesn't apply to me because I can't legally work in the first place around Title I. Now, access to services, it may or may not apply depending on the nature of the service and whether it's a state or local service or a federal service. There are certain federal laws that say certain services are only eligible for legal immigrants and legal individuals, and particularly as we've looked in the current political climate, there's been a lot of uproar about illegals and whether they're entitled to benefits and support or not. New York State, and specifically New York City, has specifically fairly consistently held that individuals, regardless of their immigration status, need to be provided certain basic services and supports for health, safety, and overall well-being. The ADA may or may not apply to them depending on the nature of the services specific.
Okay, we did have another one come in as you were speaking. So does the ADA cover any discrimination based on a former history of committing crimes, such as misdemeanors or having a DWI, in the case where it makes for a no hire or termination?
All right, here's one that is actually rather interesting because Congress had a lot of discussion when this was being debated. And Congress came down to that criminal and illegal activity is a willful act. And so if you commit an illegal act, you're not protected from discriminatory practices or behavior. And in fact, you can, in fact, be discriminated against in employment and other activities. Now that said, DWI is slightly different because now there is a record of me having an addiction problem. And that second prong of the ADA, there's a record of my disability, provides me some protection against discrimination as we go forward in the future. Not because of the illegal act, but because of the record of the disability. So illegal acts themselves are not protected by the ADA, but a record of disability does give you some protection. So could you say that I want to be a school bus driver even though I've had 10 DWI arrests? Well, the answer is no, because even though you might be protected by the ADA for the record of having a disability, you're not a qualified individual in terms of safety and what are probably going to be the occupational requirements to have a clean driving record to drive the school bus that takes kids to school. And so you have to look at every law within the construct of all of the laws associated with it. So I hope that today's webinar was helpful. We certainly will look at the next couple provisions of the ADA, and then we'll look at also the Fair Housing Act and the Federal Rehab Act, because each have some specific accommodations and specific rules that may be helpful. People often, as you know, Tony, and for our listening audience, as we talked about during this webinar, people often throw the ADA around and say, I'm protected by the ADA, without actually knowing what the ADA means. I hope that today gave you some information about what is the ADA, what is actually covered. As we talk about Title II and Title III, you'll get a better understanding of the other parts of the ADA that cover more than just employment. But for today, covering Title I was clearly something that was the highest need, and we'll cover the public accommodation piece and state and local government things.
And again, we have the JAN website up there They've been a great resource. They did a webinar for us a couple of years ago. They're a free federal resource, and they will answer questions because a lot of people have very specific questions and very specific circumstances that they're looking for answers for, which is beyond the capabilities of a webinar like this. But you can give them a call, and they can assist you on and guide you in what you can do. And then we also had up the number for the EEOC. Who does the enforcement. So, and if you feel like you've been discriminated against or want to know, you can contact them.
In that regard, Tony, I think what would make sense is I don't believe when we did the JAM webinar that we archived it. And so, okay, so we should probably put that actually on our NICE webpage to actually help people there as well. So if you're looking for more information about the JAM, specifically the Job Accommodation Network, and you're not familiar with the NICE webpage, NICE is the New York Employment Services System. I would refer you to www, and Tony, if you'll bring up that webpage, I think it would be great, .nys.ny.gov. We actually have a number of resources to help people with disabilities think about employment here. And if you look at the customer information page, you may want to just click on that to give an example of what's available there. And so we thank you all. I look forward to upcoming webinars. And Tony, do you want to give the announcement about our next webinar or where we might be going next?
Well, our next webinar will be in January, and we will do it either on the Federal Rehab Act or the
Title II or III of the ADA?
The fair housing. We're also, because we do have a lot of information that is somewhat time sensitive, we're also looking to do a webinar on the consumer assessment of care, which is coming up in April, but we start talking about it in January. And now that that is all up on the public website, it probably makes sense for us to have a little bit more of a public dialogue about that. And then we also are looking to do, so we'll probably do 2 webinars in January. We'll probably do 2 webinars in February, the second one being around how to work and win, which is one of our staff has developed an initiative down in Long Island. And actually, if you look up there, you can see right where I'm pointing with my mouse, there's a work and win guide there. So he wants to talk about that, and then we may have 2 in March as well, so we can talk about the upcoming planning with Betty P, since she did that for us last year. So we got a lot of good stuff coming up, and I do want to say I really appreciate people's participation in these, and I really appreciate people coming and all the emails and all the questions and all the dialogue that goes on after these. I hope you all keep coming. I hope you all get a lot out of this, and I hope this is very helpful for you. Again, there will be a survey that comes up. If you could just please take the time to fill that out, that would be great. Thank you very much, everyone. Bye-bye now.